You're with the hard facts from the CNN News 18 and Federal Bank Primetime Studio. Viewers, there's been a major turning point with regard to the claim made by Hindus in the Krishna Janambhoomi matter. The Allahabad High Court has ruled in favor of Hindus in a decisive intervention against the Muslim side. The Hindus have laid claim to the Krishna Bhumi. They claim that the birthplace of Lord Krishna was snatched away from the majority community in a documented act of Islamic bigotry. The temple that stood on the hallowed ground was demolished to make way for a mosque in a sinful perpetrated by the forces of Mughal Emperor Aurangzeb. The Muslim side that maintains the mosque built atop the Krishna Bhumi had challenged the Hindu claim, citing the 1991 Places of Worship Act. The 8C order now paves the way for determining the religious character of the disputed spot. Let me just take you through what transpired in the Allahabad High Court today. First things first, the Allahabad High Court ruled against the Muslim side's plea against the maintainability of the case filed by the Hindus. 18 of those pleas have now been upheld as maintainable by the Allahabad High Court. The Muslim side argued that suits were barred by Places of Worship Act that was brought onto the books in 1991 by a Congress government. The High Court refuted the argument of the August 15, 1947 cut-off via the Places of Worship Act. The Hindu side claims no property called Shahi Eidgah exists in the government records. The Hindu side claims that the Mughal-era mosque was built after demolishing a temple. The Allahabad High Court verdict paves the way for a trial on religious character of the site. Now viewers, the 1991 law is also being challenged for its dubious legal credentials. Then Congress government of P.V. Narasimha Rao had promulgated the law that places a restriction that mostly impacts Hindus. The law deems it illegal for any claim on a place of worship that may alter its character from what it was on August 15, 1947. Now viewers, this particular intervention by the Congress party to bring this law was seen as a political one, an act born out of a degree of minorityism, appeasement politics, to put it in simpler terms. Many top legal minds like Vishnu Shankar Jain, who actually got the favorable order today for the Hindu community, believe these clauses in the 1991 Places of Worship Act are arbitrary, irrational. Retrospective cutoff date cannot be something that can be upheld in law. That's what his contention is. There's an unjustified bar on remedies for encroachment, blocks judicial redress on historical injustices. Viewers, we are all equal in the eyes of the law. And the law is very simple. In its natural state, it says that all of us have a right to seek judicial redressal. How can anyone be barred from seeking judicial redressal? If they are barred and if they have a grievance, where do they go, viewers? This is out of whack with the basic structure of our Constitution, of the rights that the Constitution affords us. Beyond which, the Places of Worship Act, it is said, condones barbaric pre-independence acts of invaders, and it was passed without consulting the affected communities. With the bar on examining the character of the Krishna Janambhoomi gone, Hindus are confident of reclaiming their revered place of worship. In fact, viewers, they are confident because there is a lot of evidence now available that shows that the Krishna Janam Sthan was bona fide Hindu place of worship. You have the order of Aurangzeb, 1969-1970, in which it is detailed that a demolition of a large number of Hindu religious places and temples, including the temple standing at the birthplace of Lord Sri Krishna at Katra Keshav Dev in Mathura. The army of Aurangzeb succeeded to demolish the Keshav Dev temple, and a construction was raised named as the Eidgah Mosque. This is part of the order. The Masir-e-Alamgiri, the history of Aurangzeb, official court bulletin, January-February 1670, says the emperor, the reviver of the faith of the prophet, issued orders for the demolition of the Dehura of Keshavarai in Mathura. In a short time, the destruction of this strong foundation of infidelity was accomplished, and on its site a lofty mosque was built. The idols, large and small, of the temple were brought to Agra and buried under the steps of the mosque of Begum Shahi in order to be continually trodden upon. That was a level of cruelty, viewers. The Masir-e-Alamgiri goes on to note that the name of Mathura was changed to Islamabad. Italian traveller's account from Aurangzeb's court, Nicola Manucci, book Storia do Mogar, 1653 to 1708, details several important places, including the Krishna Janambhoomi and Mathura, were demolished by Aurangzeb. Thereafter, Hindus thronged the sacred site and started worshipping as they were doing in the past. Historian Jadunath Sarkar, in his book Anecdotes of Aurangzeb, 1917, says, and I quote, in April 1669, he ordered the provincial governors to destroy the temples and schools of the Brahmins and to utterly put down the teachings and religious practices of the infidels. The grandest shrine of Mathura, Kesav Rai's temple, built by the Bundela Raja Bir Singh Dev, was razed to the ground in January 1670, and a mosque was built on the site. There's a lot that goes on, viewers. Let's open this up. Let's ask some fundamental questions. The most obvious one here now is, given that the Muslim side has suffered a massive setback, what really are the implications? Vishnu Shankar Jain, let me bring you in first and talk us through, number one, what happened in court today. You are, of course, to be congratulated because you're being representing the Hindu side in this matter and you've got a favorable order. Is it a game-changing one? And if it is so, why is it so?
See, definitely, Rahul, in any civil suit, the most important stage of the civil suit is to cross the stage of Order 7, Rule 11. Because if the suit is dismissed on the ground of Order 7, Rule 11, the suit itself is not maintainable, and then it's dismissed at the threshold. And that was precisely the effort of Shahi Eidgah Masjid, that to see that this is nipped in the bud and this does not move forward for more reasons than one. The point is this, that before the Honorable High Court today, the issue which transpired was that the argument of Shahi Eidgah Masjid is in suits by Places of Worship Act, Waqf Act, Limitation Act 1963, Specific Relief Act, and Order 23, Rule 3A. These are the 5 laws which were cited by the Shahi Eidgah Mosque before the Honorable Allahabad High Court. After detailed hearing of 4 months, the Honorable Allahabad High Court has rejected the application of Order 7, Rule 11 filed by Shahi Eidgah Masjid. And precisely two things are very important, which is our bone of contention. To defeat the argument of Places of Worship Act, 2 points are there, Rahul. First of all, let me tell you, Shahi Eidgah Mosque is under the control of Archaeological Survey of India. If any monument is under the control of ASI, under the Places of Worship Act, Section 4, Subclause 3, it is mentioned that the Places of Worship Act will not apply. So that is point number 1. Point number 2, Places of Worship Act, Section 4, Subclause 1 and 4, Subclause 2 uses the word religious character. So our argument was, our contention before the Honorable High Court was that Places of Worship Act gives the freedom to determine the religious character by way of a lawsuit, by way of evidence in the court. And this interpretation was accepted by the Honorable Allahabad High Court Coordinate Bench in Gyanvyapi case on 19th of December 2023 by Honorable Mr. Justice Rohit Ranjan Agarwal. A very detailed judgment is there. So that was another bone of contention. Point number 2, on the aspect of Waqf Act, we had given a lot of research before the Honorable High Court. And research is this, that the effort of Shahi Eidgah Mosque was that this case should travel before the Waqf Tribunal, which is a Sharia court, and it should not be tried before the Honorable Allahabad High Court. We had cited the judgment of Supreme Court in 1979, 3-judge bench judgment, as well as the judgment of Supreme Court in 2010, Ramesh Govindram's case and Board of Muslim Waqf's case. In both the cases, the Honorable Supreme Court has held that if one party is non-Muslim, on that the notification of waqf will not apply. So
Right.
these were the factors on the basis of which I think, and on the basis of this research, this particular judgment has been delivered by the Honorable High
So
Court.
let me ask you now. Obviously, there are large number of places of worship that are protected by the ASI, Vishnu Shankar Jain. So does that open the doors to determine the character of those places of worship also, which may be taken away from the Hindus in the past?
Very interesting question you have asked, Rahul. And the answer is in the ASI Act 1958. Under Section 16 of the ASI Act 1958, it is a mandate given to the ASI by the Parliament that ASI will not do anything in any property which is under its control, which is a shrine or any religious structure, against its religious character. And therefore, in Bhoshala's case, by virtue of this word religious character, the Honorable Division Bench of the Indore High Court had directed the ASI survey, which went on for 98 days, and ultimately the report has been filed. So the mandate given to the ASI under the ASI Act is that you will not do anything against a protected monument, which is a shrine, mosque, or a temple, which is against its religious character. So, what is the religious character of Shahidgah Mosque? This can be ascertained by the ASI. And let me also tell you that when it's a ASI protected monument, ASI has full powers to do the survey, to do the excavation. They do not need the court orders, and they can proceed with the matter because its property is within their domain and
And
control.
you said that this is what clause of the ASI Act of 1958?
Section 16,
Section 16. So viewers,
1-6.
yeah, so this basically suggests that perhaps other Hindu groups could move applications to determine the religious characters of other places that of worship that are disputed, viewers, after today, citing this Allahabad High Court order. Yes, Vishnu Shankar Jain, am I right or am I wrong?
Yes, absolutely wrong. These are precedents
So
which are laid down.
Theoretically, viewers, the Hindu community can now move forward with greater confidence. Okay, let's open this up because Rahul Ishwar is there with us also. We have Kamru Chaudhary. Kamru Chaudhary represents the Congress party point of view. Now, Mr. Chaudhary, look, this 1991 Congress era shield for Muslims, and I'm not only saying Muslims, but predominantly it would have helped Muslims most. So that is why I've used that term selectively. Don't hold it against me. So I'm cutting to the chase, so to speak, being exact. This shield now is crumbling. And I want to ask you, since there is now a precedent to go ahead and determine the religious character of disputed sites, would you still say that it should not be done? Should now Hindus move forward? There are about 30,000 disputed temples, apparently. And their antecedents, the Hindus claim, are very much desecrated, have been taken over by the Muslim community, etc. Now this gives us hope to move forward and open those doors to investigate what lies beneath. Would you support that kind of inquiry, Mr. Kamru Chaudhary?
Yeah, Rahul, we are treading on thin ice. Let us not call this a dispute between Hindu side and a Muslim side. Let us not create further divisions within the society for what happened around 500 years ago. My first point of view. My second point will be, the taking advantage of the ambiguity in the Places of Worship Act 1991, the basic intent with which the law was framed cannot be simply wished away by manipulating the majoritarian opinion and igniting centuries-old passion based on astha and devoid of facts. Why I say this? You have just now said the Archaeological Act, ASI Act of 1958. That means anything prior to that. That is, we attained the independence. Our Indian civilization started from 1947 as an independent nation. And we all agreed as per 1991 Act that any dispute bearing the, the Ram Janmabhoomi dispute, everything has to be decided on the basis of the Places of Worship Act 1991. The religious character of that place has to be ascertained. Now, where is the ambiguity? Ambiguity is the clause B of that, which debars anything that is under an ASI protected monument or of national importance that cannot be falling under this This is an ambiguity which the present Narendra Modi government must immediately correct, and the
Oh,
Places of Worship Act must be amended to protect these historical places of worship or historical monuments, so that every mosque or every temple in the country cannot be under the rule of the fanatics trying to reclaim what Aurangzeb did or some other Mughal ruler did some 400 to 500 years
okay. But
ago.
now one
As
second.
RSS
Let
chief
me
has
bring
said,
in.
let me
Let me
just
bring
finish.
in. Okay.
Let me just finish.
Yeah.
As RSS chief has said, please do not look for a temple under every mosque in the
Yes, I
country.
quoted them.
It
I
will
quoted him
open.
in my book also. I quoted him in my
Yeah,
book, but
yeah. I've
there
read
was a
your book
proviso.
also.
Yes, sir.
Yes.
No, thank you, Kamru Saab. But I just have to say at this point, look, you said that let's not make this a matter of dispute between two communities. Now, Rahul Ishwar, before I bring in Vishnu Shankar Jain on the point of law that Kamru Chaudhary has raised, I just want to bring you in. Rahul Ishwar, there would be no dispute if the contending occupying side would give up its claim, especially in those places of worship where it's quite apparent what has happened.
Rahul Shivshankarji, two submissions. First of all, beneath every mosque, beneath every church and every temple is the soil of India that we stand on. Let us remember that and debate on this very sensitive issue. I think that's a fair position to start with. Second, there are various hues of positions inside the Hindu community regarding this sensitive matter. Pujaniya Sarsanchalak Mohan Bhagawatji's position, is very statesmanly. People like Subramanya Swami, who were very strong on this. Even Subramanya Swami says, let places of Ashpac remain the same, but let us have some exceptions to it, include Kashi and Mathura to it. There are people like Sadhguru, who's a very prominent guru who is respected across the world, supports the position that places of worship act need not be disturbed, but one or two or three exceptions can be made. My good friend Jain Saab, his very respected father, our good friend Saidi, but argues for a much stronger position, saying that there has been historical injustices being done, so we should rectify. So there are nuanced positions. Hindu community always had a healthy difference between such views, and we should respectfully address that. And there are even people like KK Muhammad who goes on record to say that let us accept that there were some injustices in the past. And there are some spaces where if we can have something like an understanding between communities, that will give a lot of goodwill. For example, Janmastans cannot be changed. Sri Ram Janmastan cannot be changed. Sri Krishna Janmastan cannot be changed. There are some places which is having some kind of sanctity that is beyond a temple. Every temple is having utmost sanctity, but beyond a temple, Janmastans have their own, that special accordance. So is there a possibility where we can talk to each other as mature adults, as consensus building individuals? That's what Honorable Supreme Court did when they
Okay.
commissioned people like Sri Sri Ravi Shankar to talk to each other.
So you're saying that, look, let's then resolve that those sites which are of particular reverence to Hindus, maybe the community that is occupying it right now can concede. Right? That's what you're basically saying.
Just one more line. A figure like 30,000 may create a panic button in our Muslim brothers. Let's be honest
so let's
about
not
it.
go
But
to the
there are
larger
some
number,
spaces.
but certainly at least look at those that are of material significance. Okay, Vishnu Shankar Jain ji, now in your interactions, look, I mean, we have all the evidence here. It's very clear visibly also that there was a temple below the structure that is standing right now in the Krishna Bhumi. Now, in your interactions, obviously with the other side, there must have been an opportunity to try and arrive at a compromise. Did you sense that from the Muslim side, or are you just being forceful? Because that is the charge, that you are trying to, scratch at old wounds, you're trying to sort of, create bad blood, as Mr. Chaudhary is suggesting.
Rahul, I think in the beginning of the show, you had quoted the Farman of Aurangzeb.
Yeah.
And the Farman of the Aurangzeb, I don't want to repeat it again and again. It is so demeaning, and it is against the dignity of every individual.
Yeah.
Making a leveling a charge against me that I am trying to scratch the old wounds. If this Farman is there in the history books and this Farman has been acted upon, Rahul, I ask a question to myself: do I have a right to get my dignity back? Don't I have a right to get my glory back? This 13.37 acres of land, Rahul, I must tell you, was auctioned by the British government in 1815, and it was purchased in auction by Raja Patnimal of Banaras in 1815. So the original title documents of this property are with us. and you are sitting over this property by making an illegal encroachment. And today, by a lawsuit, by democratic process, by constitutional process, I want to get this so-called encroachment removed. So you are saying that I am trying to make communal tensions in the country. I am saying, what kind of this tension is this? You have buried my idols in Begum Shahi Mosque of Agra, so that when they go and offer namaz, it can be continually trodden upon. I dare Mr. Kamru Chaudhary that he says that yes, those idols should be brought back. आप जब नमाज
Mr.
पढ़ने जा
Chaudhary?
रहे हैं, मूर्तियों के ऊपर कुचलते हुए जा रहे हैं, और उसके लिए
No, Rahul, Mr. Jain, no need to get excited. There are a lot of violent past that we have gone
No,
through.
this is a
through pages of
current, this is a
history.
present, ongoing, ongoing
No,
problem.
no, you can come and say that I'm Rahul, that you can.
There's something wrong with the audio, Vishnu Shankar Jain. Yes.
Hello.
Yeah,
Hello.
yeah, I can hear you.
Am I audible?
Yeah, you are audible.
Am I audible?
Yes, Mr. Chaudhary,
Okay.
you're saying that, look, leave bygones be bygones. That's what you're saying, right? But when there are individuals, I mean, Vishnu Shankar Jain, why don't you respond? Let bygones be bygones, he says.
Rahul, I want to ask a question. That when this position is argued before the court and outside the court, that once a mosque, always a mosque. Once a waqf, always a waqf. It is on the first principles of Islamic law. Now the Hindu Shastric law is what? Once a temple, always a temple.
That's true.
Once a property vests in the deity, till the end of the time it remains deity's property. Now today, here I am with all the title documents and all the documents saying that this is a case
So
of
let me ask
encroachment.
then, Atikur Rahman, for some people, certain places of worship hold huge significance. And if there is a visible occupation, who is standing in the way? Obviously, it is the community that is occupying that. Has the time come to make a concession in the interests of communal amity, sir?
Wonderful, Rahul. Rahul, the beauty of this entire dispute about the Krishna Janmabhoomi and the Eidgah Masjid is that the battle is fought between the main parties, the contenders, and the fight is in the courts. So both the parties are taking cue from the legalities and the technicalities involved. So better the communities, both Hindus and Muslims, and mainly the political parties are away from it. Whatever is being decided will be decided in the court of law based on the arguments of both the parties, and the court shall decide. What I am worried about is, if any, in the coming days and months and weeks, if any of the political parties take it as their this thing on their manifesto that we will be fighting, so they are away from it, fine, very good. The people of India will be watching what laws are being bypassed, what acts of the parliament in 1991, which gave a sigh of relief to the entire length and breadth of India.
But are you suggesting, sir, that the courts are undermining? No, are you suggesting that the courts are undermining the Places of Worship Act? What are you saying?
No. The Supreme Court the other day, the Supreme Court on the same matter had, gave a very different perception. Then again it went to the High Court, and we are now discussing the High Court matter. Maybe in the Supreme Court the things might change. What I am basing my argument is, let the law of India decide.
Okay, so Mr.
The
Kamru
fate
Chaudhary,
of
what is the
India-
hassle? If there are many places of worship that are in dispute, let the matter go to the court. Why are you sitting here and saying that don't scratch at wounds and don't do this and don't do that? Why are you making people feel bad about trying to restore pride in their places of worship or derive dignity? One
Yeah,
second.
Rahul, permit me just 1 minute, before I
Let
complete this
Let
argument.
them do it, he's saying.
Yeah, let me come to the basic argument out here. The basic argument in the Eidgah case.
Okay. Yeah.
Basic
Chaudhary, sir.
argument in the Eidgah case of the Allahabad High Court, wherein the RTI filed by Ajay Pratap Singh. That is the basics of the main argument. In November 1920, they found an expert from the book which says portion of the Katra mound which are not in the possession of the Nazul tenants, on which formerly stood a temple of Keshav Dev, which was dismantled and the site utilized. That's a fact. It's a recorded from the history on 1920.
Yeah.
But the point here is that That is which being disputed by the Muslim side or the Sunni Waqf board out here is that the mosque does not fall within the
Okay, very
13.77
quickly.
acres of disputed
Okay,
territory out here.
Mr.
But
Mr.
the
Jain,
point
Exactly.
Mr.
that
Jain
Mr.
wants to come in.
Jain will want
Yes.
to bring in
Rahul,
is that the entire mosque, the entire 13.77 acres, everything is disputed. There is a
Okay.
question of dispute.
Very
Rahul,
quickly, Mr. Jain.
Rahul, very interestingly. Now, today, Mr. Kamru Chaudhary has made a statement before you saying that this mosque is outside the 13.37 acres of land. Precisely, this is what his stand is. Now, I am asking, this is precisely what we are asking before the Honorable Court, that let's do a survey. Let's do a mean survey. Let's see
I've lost
whether
your
it
audio.
falls-
Yeah. Now it's come back.
Can
yes.
you hear-
yeah.
Rahul,
You
can you
said
hear
let's
me?
do a survey. Let's do a survey to
Let's
determine.
do a mean. Let's do a mean survey
Okay.
to determine that whether this mosque is within 13.37 acres or not.
Okay.
The moment I ask this, Rahul, the moment I ask this, he will say that your case is not maintainable. It should be nipped in the bud.
Well, viewers, look, the last word has not been said, and we don't want to prejudge any of these issues. These are sensitive matters, but you've heard the arguments on both sides. I think the way forward is the democratic process which Vishnu Shankar Jain is for, and you cannot fault him for believing in something greater than himself. You can't fault him. I leave it at this, viewers. We are coming right back with another big story.